Thank you. Okay. Good afternoon and welcome to the Joint Standing Committee on Health Coverage Insurance and Financial Services. We are gathered this afternoon for some work sessions as we try to wrap up our committee work. We are going to begin with a discussion of the change package that the governor has proposed related to the budget. Then we will take up the bills in the order listed in our committee schedule for the day. So in numerical order, as far as I'm aware right now. So that's the plan for the afternoon, and we'll start with introductions. And I'll start with Representative Arford.
Thank you, Madam Chair, and good afternoon, everybody. I am Poppy Arford. I represent District 49, which is the western part of Brunswick.
And Representative Evans.
Thank you, Madam Chair. I am Richard Evans. I represent House District 120, including the towns of Brownville, Atkinson, Dover, Foxcroft, Medford, Milo, Orneville Township, and Lakeview Plantation. Thank you.
And Representative Bleier.
Thank you, Madam Chair. Good afternoon, everyone. My name is Mark Bleier. I represent District 22, which is Leamington and part of Buxton, Standish, and Limerick.
And Representative Matheson, if you're here and can hear us, you can go ahead and introduce yourself.
Thank you so much. My name is Christy Matheson. I represent District 1, Kittery.
Representative Melrano.
Good afternoon. My name is Gina Melrano. I represent House District 62, which is part of Auburn.
Representative Brooks.
Good morning, good afternoon. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Senator Bernhardt.
Thank you, Madam Chair. My name is Stacey Brenner. I represent Senate District 30, which is Gorham, most of Scarborough, and part of Buxton.
Representative Morris.
Good afternoon. I'm State Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and Livermore.
Representative Tepler.
Good afternoon. I am Denise Tepler, State Representative for House District number 54, which is all of my sweet town of Topsom, and I serve as co-chair of the committee.
What's that?
Senator Brenner, did she introduce herself?
I got Senator Brenner. And I'm Senator Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. We are assisted today by Colleen McCarthy-Reed from OPLA and our stand-in clerk, who's been wonderfully helpful, Sabrina Carey. So we are going to pick up the budget items first. So I'll turn it over to Colleen to walk us through what we need to know.
Sure, thanks. There were two budget items proposed as part of the change package, and I had emailed them earlier, but I'll just share them with you quickly. The Appropriations Committee has asked each policy committee to take straw votes, which is what we did on the earlier initiatives, and send those along to the Appropriations Committee with your recommendations on as the change package proposes a couple of discrete changes to our earlier report back. So I'll pull this up really quickly and walk you through the two items. And as I said, I think we can just do a straw vote and then send that memo along to the Appropriations Committee. The first change is this would make permanent the positions that the committee discussed earlier this session with Commissioner Head. You'll recall when you discussed some of the challenges and delays that the licensing division is facing, particularly with regard to licensing of mental health professionals. Commissioner Head suggested adding 2 positions for a limited period through financial order, and this proposed amendment in the change package would make each of those continue those limited period positions that were originally created by financial order and make them permanent and provide the allocations of other special revenue funds for those two positions. So maybe if we just take it one by one, I'll stop sharing and then folks want to discuss it.
Pardon me.
No, I don't know if that's me or you. So folks want to discuss it. I'm happy to answer any questions. Otherwise, just a show of hands would work for purposes of reporting back to the committee.
Representative Tepler.
Thank you, Madam Chair. And I just want to say that I think this is a very good idea, that it's clear that to process the number of applications that the boards have from both in-state and out of state, we need to make sure that particularly in the counseling professions, there are enough people to help process the applications.
Representative Morris.
Thank you, Madam Chair. And if I am, I believe this comes out of the dedicated revenue fund that for these departments, for the department. Okay. No, then I think certainly I have no concerns about it. I think it's something that we determined to be necessary a while back. I think particularly given that we just passed the telehealth bill last week, it's going to be important to make sure that that any licenses are processed quickly and expediently. So I have no issues with the positions.
Thanks, Representative Morris. Are there any other comments? All right, so you want to do a straw vote on this one before we move on? Okay,
Sure.
So we'll just do it. It might actually be easier if we just raise our electronic hands. All those in favor of this initiative in the change package, could you raise your electronic hand?
Great. Thank
Okay.
you. It's unanimous.
Unanimous of the
Of
10
those
folks present.
Great. Thank you.
Great.
And then the next one. The next one, this is just correcting something that was inadvertently left out of the original bill. This was with regard to the Board of Licensure in Medicine. This would restore a position or not even a full position that recognizes one of the members of the Board of Licensure in Medicine that was inadvertently removed and made a limited period position in error as part of a fiscal note to legislation earlier this session. And this would restore that position to permanent status. That's the second change.
That's weird. Okay.
Yeah.
Was it legislation that we passed? It's fine. You don't need to look it up.
Yeah, it was, and I don't know what the fiscal office explained it to me. I don't know what the situation was
Okay.
and why it was done, but it's just correcting some of the budgeting in how they had accounted for it in the positions. So.
Okay. Is there any discussion on this item? All right, seeing none, we'll just vote by electronic hand in favor of the initiative. All right.
Looks good. Thank you.
Yep, that was 10 members in favor.
Yep. So that will go on to appropriations this afternoon. Thank you very much.
Okay, great. Were the other three there were a couple of initiatives, or were there no initiatives at all in the first budget?
As part of LD 221, there were a number of initiatives within the all of the agencies. Those remain unchanged as part of the change package. I'm happy to re-forward the memo with the worksheets to the committee for both. I'll send that again to everybody to refresh your memory, in addition to the memo that I send off on the change package items.
Okay, Great.
These were the only two additions, and we had supported the creation of the limited period positions as part of our initial report back. They
Yep.
did that through financial order, and then this reflects it on a permanent basis.
Great. Thank you. Representative Tepler.
Thanks, Madam Chair. I just wanted to remind you that that included the original 221 included some monies from MHDO that had been used for a program that they were examining infections in hospitals, and they weren't able to do that during the pandemic. So those savings were allocated elsewhere.
Okay. All right, so the first bill that we're going to take up today is LD 1266, which is the dental loss ratio bill. Colleen, I believe we've had prior work session on this one. Is that right?
I'm not sure if we ever actually went through the whole analysis. I know we've postponed it a number of times, but I know you've seen this you've seen the information, and you've had some follow-up information sort of throughout the session. So whatever you'd like me to do, I'm happy to.
So I'm going to suggest, folks, that this is my bill, and I am going to suggest that we carry this one over. I have not had the time this spring to dig in and work on it as I expected that I would. I will just give you guys sort of an insight and give anyone listening an insight that I anticipate adding a ramp into it, a ramp for the MLR. It's not in there now, and I have not sat down to do the sort of analysis of what that ramp should look like. And I was hoping to get to it this week, but I didn't. And I really like this idea. I don't want to kill the bill, and I'd like the additional time over the interim to work on it with folks who are better at math than I am and can do it not on the back of an envelope, but in a bit more of a controlled way during the interim. So that is where my head is at right now. Representative Tepler.
Thank you, Madam Chair. I was just going to make a motion if you're ready for one.
Sure, we can put a motion on the table.
Okay, I'll move that we carry over LD, is it 1266?
Yeah. Okay, it's been moved for carryover. Is there a second? Representative Brooks, I saw your hand. Thank you. So it's been moved and seconded. Are there further comments on the carryover suggestion, the carryover motion? Okay. So the clerk will call the roll.
Okay. Representative Quint. Absent. Representative Connor. Absent. Representative Blyer.
No.
Representative Morris.
No.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malronio.
Yes.
Senator Brooks.
Yes.
Senator Stewart. Absent. Senator Brenner.
Yes.
Representative Tepler.
Yes.
Senator Sanborn.
Yes.
8 yes, 2 no, 3 absent.
All right. Thank you, Sabrina. All right. So next we'll move on to LD 1584. And I'm going to have Colleen do her analysis presentation on this one. Whoops.
Sorry, I didn't mean to. I hit the wrong button. There we go. I just couldn't find it. Here's SB 1584. This is Senator Claxton's bill that we heard last week, an act to make donated medicines available to Maine patients at an affordable cost. As it's drafted, the bill would establish what's called the Maine Medicine Donation and Redispensing Program. It directs the Department of Health and Human Services to contract with nonprofit entities to administer the program. It's designed to collect donations of unused medicines from healthcare providers, facilities, and other sources, including individuals, and to redispense those medicines to qualified low-income persons. The bill specifies that persons are eligible to receive medicine under the program if it should say do not have health insurance or are enrolled in a public assistance program or otherwise meet criteria that are directed to be established by the department by rule. Donated medicines under the provisions of the bill must be in the medicine's original unopened sealed packaging, or if the outside packaging is open or disturbed, the contents are one or more single unit doses that are individually contained in unopened tamper evidence packaging. There is an exception for orally administered cancer medicine for that to be in opened packaging. Controlled substances may not be donated under the program, and donated medicines must meet federal requirements relating to risk and evaluation strategies and supply chain security. There's a additional provision in this bill that would provide a tax credit beginning in January 1 of 2022 for individuals that make donations of medicines to the program. This is similar to a bill that was considered by the HCIFS committee in the 129th legislature. That bill, LD 1661, was voted ought to pass as amended by the committee. It was enacted by the House in the first session and then referred to the special appropriations table at the end of the first regular session, and then carried over, but stayed on the special appropriations table at the end of the second session last year, and so was not fully acted upon by the legislature before the 129th legislature ended. While LD 1661 would have directed the Department of Health and Human Services to oversee and administer the program, LD 1584 has been amended primarily in its provision that would require DHHS to contract with nonprofit organizations to administer the program. A couple of pieces of written testimony that were submitted that I wanted to make note of. The Retail Association of Maine does have concerns that pharmacies would not be able to meet the requirements in the bill, particularly related to supply chain security. And they suggested that the committee might consider amending the bill to remove the ability for individuals to make donations and instead to specify that donations may be made only by professionally designated persons like healthcare facilities and other pharmacies and other entities where it would be easier to track that supply chain. Maine Revenue Services submitted written testimony related to the tax credit provision included in the bill. They raised some technical concerns with the language as drafted. They also indicated that there is an existing provision for individuals who do not itemize for purposes of that do itemize, that there is an availability of a charitable donation deduction, and they questioned whether this would provide the ability for someone to take advantage of a deduction under both provisions with regard to donated medicines. They also indicated that there are some administrative costs if the legislation moved forward, approximately $33,000 for computer programming changes related to adding a line on the tax return. They also indicated the potential for adding an additional position within Maine Revenue Services to administer the provision. We don't yet have any specific fiscal information from the Office of Fiscal and Program Review on this bill. I'm happy to answer any questions. I didn't have a chance to peek to see if the sponsor was here as well.
I haven't
yet,
looked either.
I don't know. Yeah, I know he indicated an interest in attending, but thank you.
That's true. All right, I'll shoot him a quick text to make sure he knows we're talking about his bill. But I would ask if there's any questions for Colleen. All right, I have a couple of suggestions as far as amendments that I'd like to throw out there to the committee for discussion. One is to delete the tax provision. Now I'm talking about the bill without texting Senator Claxton. So let me just take a pause and do that really quickly. The first would be amending it to delete the tax provision. And then the second would be to narrow the scope of who could donate to, I'm not sure what the right phrasing would be, Colleen, but I'm thinking basically licensed entities. So group homes or hospice care facilities or nursing homes, those types of places. Where there's sort of an overseeing kind of thing rather than just individuals sending them in the mail. So those were my two suggestions. I think that makes it easier for retail pharmacies to be able to comply with, and I think it captures the bulk of what the problem is that the bill tries to solve. Representative Morris.
Thank you, Madam Chair. I would agree with your amendments, and I would move ought to pass as amended by your two amendments.
Okay.
I'll second that.
Thanks, Senator Brenner. Did you have any other comments, Senator Brenner?
I just wanted to say how much I appreciate this bill, and I think the amendments help to strengthen it. Thank you.
Great. Is there any further discussion? All right. I think that was just Denise waving at something. That wasn't you putting your hand up. Okay. All right. Then seeing no further discussions, the clerk will call the roll.
Representative Quint, absent. Representative Connor, absent. Representative Blyer,
Yes.
Representative Morris,
Yes.
Representative Matheson,
Yes.
Representative Evans,
Yes.
Representative Arford,
You're on mute.
Yes.
Representative Malrano,
Yes.
Senator Brooks,
Yes.
Senator Stewart, absent. Senator Brenner,
Yes.
Representative Tepler,
Yes.
Senator Sanborn.
Yes.
10 yes, 3 absent.
Okay. The next bill we're going to take up is LD 1645. And on this one, I do just want to give the sponsor a moment. So we'll pause for just a moment. Oh, just occurred to me, I'm not sure if on 1266 we got the minority report. Colleen, did you get that, or Sabrina, did you get that? I assume it's on not to pass.
Well, with the carryover, it's really just not in favor of the carryover.
Oh, okay,
It's kind of
perfect.
like a straw vote, so I think we're
Okay.
set. Thanks.
All right. Colleen, you can go ahead and start presenting, and Senator Vitelli is going to join us shortly.
Okay, great. So here is LD 1645. This is an act to establish protections for private student loan borrowers and a registry of lenders. As drafted, the bill directs that private lenders of post-secondary education financing, regardless of whether the education is provided by businesses authorized to do business in or accredited by the state, must register with the Superintendent of Consumer Credit Protection. And the bill requires the superintendent to publish a registry of those private lenders on a publicly accessible website. The bill also provides co-signers of private student financing the same rights and protections afforded primary student borrowers of private student financing. The bill includes enforcement mechanisms, so it provides for fines, suspension from operating in the state. There also are criminal liability provisions and private rights of action provisions against lenders of private student financing that violate the provisions in the bill as drafted. The bill also contains provisions for private education lenders to provide information and disclosures to borrowers and co-signers of these private education loans. There are provisions included to allow co-signers to be released from obligations under a private education loan. Provides for the discharge of the loan or release of a co-signer if the borrower or co-signer dies or suffers a total or permanent disability. There also are provisions requiring lenders to provide alternative repayment options. There are prohibitions on accelerating loan payments and requirements related to the collection of delinquent private education loans. There are some provisions in current law, which I think committee members who have served previously will recall. We've considered legislation related to these issues in the past. And during the 129th legislation was enacted to put in place requirements regulating student loan servicers, and included also the creation of a student loan ombudsman program to provide assistance to student loan borrowers in the state within the Bureau of Consumer Credit Protection. This law became effective in January of 2020. Senator Vitelli, as the sponsor, did suggest an amendment at the hearing when she provided her written testimony that would exempt loans made and insured by Maine, the Finance Authority of Maine, from the provisions in the bill. And so it would make that amendment proposed to make changes in certain definitions of terms used in the bill. You also received testimony from representatives of the Maine Bankers Association and the Maine Credit Union League, suggesting that the committee exempt loans made by their institutions from the requirements of the bill. As drafted, the bill would treat state chartered banks and credit unions differently than federally chartered banks and credit unions. And as we've discussed before, federal law would preempt the application of the bill's provisions to federally chartered banks and credit unions. And you've had discussions related to various bills about the potential for a different sort of playing field for federally chartered banks and state chartered institutions. And these issues of parity between state and federal law were also noted in the written testimony that you received from the Bureau of Financial Institutions as something that you might want to consider as you discuss LD 1645. The Bureau of Consumer Credit Protection, their testimony noted the new requirements in the bill and sort of the addition of new regulatory functions to the Bureau, and raised potential concerns about the additional personnel and funding that would be required to perform those new functions. I was able to share a revised amendment to all of you earlier that proposed by Senator Vitelli that attempts to address concerns raised at the hearing by several parties. So I'm happy to review that amendment for you if you would like. And then lastly, I would note that each of the bill creates sort of 2 new articles within the Consumer Credit Code, and as part of the enforcement mechanisms for each of the articles would establish that a violation of each would be a Class E crime. And while we've talked about bills that propose new public records exceptions, I don't think we often talk about bills that contain provisions creating new crimes, but there is a process required under the joint rules that if a committee moves forward with legislation that creates a new crime or enhances criminal penalties, that those provisions must be reviewed by the Criminal Justice and Public Safety Committee prior to their enactment for their impact on the criminal justice system. So if the committee moves forward with the bill, I either as drafted or as amended, and it includes criminal penalty provisions. Those provisions would be reviewed by the Criminal Justice and Public Safety Committee. And we don't yet have any specific fiscal information, although I would note the Bureau of Consumer Credit Protection did in their testimony raise the potential need for additional funding and personnel. I'll stop there. And as I said, I'm happy to pull up the proposed amendment if that's something the committee is interested in. I also did share with you additional written information that from the Bureau of, from the Maine Bankers Association, indicating that they still remain opposed to the amendment that Senator Vitelli shared earlier because it does not provide sort of a full exemption for state chartered banks and from the provisions of the legislation. Happy to answer any questions.
So Representative Tepler, go ahead.
Thank you, Madam Chair, and thank you, Colleen. Colleen, can you tell me if the legislation that we previously moved through committee that deals with rent-a-bank concerns, I think it was a consumer credit protection piece, whether it includes student loan providers in a way that would prevent sort of using state chartered banks as shadow banks?
You're talking about Senator Bennett's legislation that was considered earlier this session?
Yes.
I'll have to go back and look at that to see if there was some narrow distinction of that bill as it relates to consumer credit particularly. While I think there was some, I'm happy to go back and look at that language, but typically there's a specific definition of what's considered a consumer loan for personal or household uses, and I'm not sure if that would encompass student lending. And I'm just looking to see if Mr. Lund is here and could comment on that in the attendee list particularly, but I'm happy to sort of pull that up quickly and check on that. I know the language of the sort of enforcement provision that you included in LD 522 was broad to sort of get at, as broad as possible to get at any type of entity that might be violating the provisions, but I don't know if the scope of it is limited to consumer credit loans only, and it may not extend to student lending. So I'd have to double check on that for you.
Thank you. And Mr. Lund is present if you think he would know. He hasn't raised his hand though, so maybe he
didn't see him.
He is there. Yeah, if Mr. Lund could speak to the question of the rent-a-bank intersection here, it would be great. So I will. Someone already brought him in. Yeah.
Yeah, he raised his hand. Great, thanks. And I'm going to pull up that amendment right now so I can double check it too. Oops.
I assume he's coming. Is he stuck in the wormhole? No, he's not coming. Okay.
I did it, so I don't know if it'll work.
Oh, okay.
Maybe second time is the charm.
Right. I got the message that he's coming. So I think he's just got a very
There
long
he is.
wormhole.
Okay, great. There he is.
All right. Are you able to hear us, Superintendent? There you are.
Yes, thank you. Sorry for the delay.
No, you had a long wormhole today, I think that's all. So we are trying to wrap our heads around this rent-a-blank thing, which I think we have passed now through the chambers. That was in Senator Bennett's bill, and whether it would help us here at all.
That's a good question. That related to a concept called the true lender rule.
Mm-hmm.
And it really impacts non-banks more than it impacts banks. In other words, the purpose, as I understand it, of 522 was to not allow a non-bank to take advantage of preemptive authority of a bank that would have that preemptive authority. So I'm not that bill changed a lot in the process, and I may not have a clear grasp, but basically 522, as I understand it, has less of an impact on the banks than it does on the non-banks that would otherwise be able to piggyback onto the preemptive authority of a bank in making loans. There may be some overlap with the different concepts here of the student financing company in the first article and a private education lender in the second. Most education loans are encompassed by the Consumer Credit Code, with the exception of loans that have a certain low rate of interest. In order to be considered a supervised loan, an unsecured loan has to be made at a rate in excess of 12.25%. So this bill before you, 1645, could well have the impact of bringing regulatory authority over student loans that would otherwise escape at least the supervised lender authorities in the Consumer Credit Code currently.
Okay, that's really helpful. I think we did have that question during the public hearing, so that's really helpful context about supervised lending. So I think this is precisely our question, and maybe the answer is just to add a cross-reference or just to make it clear somehow that we don't want private student lenders that are non-bank companies to piggyback on the preemptive language that we are about to discuss, at least if we aren't already discussing, putting in there for banks and credit unions. So I'm not sure that was a question, but I guess I'm just suggesting that maybe we could add a cross-reference to what we've already done in the other bill. Colleen, does that make sense?
Yep. Yes, I think so. Yeah. So you would want by an additional any entity subject to LD 1645 to be subject to the same provisions in LD 522 that you added related to the non-bank lending that you're just talking about. So yeah, we could do it through cross-reference. It's probably the easiest way to do it.
Does that make sense to you, Superintendent, just in terms of we're trying to make sure that if we take state chartered banks out of this, that doesn't provide a backdoor for private lenders that are exactly the people we're trying to regulate to just piggyback on their preemption or on their exemption.
That does make sense, yes.
Okay, great. Okay, so that was one piece, and maybe that is a method of squaring the circle here. I am going to invite Mr. Frotman in to sort of give us some thoughts on that potential solution. So I'm going to promote him now. Good afternoon. Can you remind us of who you are and then give us some thoughts on whether this rent-to-bank language might be helpful?
Absolutely. So my name is Seth Frotman. I'm the executive director of the Student Borrower Protection Center. I was lucky enough to testify earlier this month on the legislation. So I think to kind of like lay the framework. So I think what the amendment before you did, I think, was try to thread the needle on the issues raised by the main state chartered banks and credit unions, which was to take their recommendation of changing the regulatory structure to one in which they are more accustomed to under the superintendent of financial institutions, but continue to retain some of the protections of the bill, which wouldn't be there in the case of a full exemption. So one of these, for example, is a prohibition against not including disability discharge for borrowers with a student loan who become totally and permanently disabled, or protections for borrowers who are cosigners, like grandparents or parents. So I think what the amendment before you has, and obviously this is totally a policy decision, is whether that struck the right balance to ensure that even loans made by state chartered institutions have to abide by the statutory protections, but switching the regulatory structure by one in which the state chartered institutions stay under their traditional regulator, and then creating some coordination between that office and Superintendent Lund's office. Did I get that right, Superintendent Lund?
And I love the amendment. I think you did a wonderful job on it, but the banks and credit unions appear to still be opposed. And so, and they raised this point of the level playing fields with federally chartered banks. And my understanding, and I think this is correct, that if Wells Fargo or Bank of America is doing student lending in Maine, they will not have to comply with any provision of this bill. Is that true?
So I think what Senator Vitale tried to do, and I think the National Bank Act prohibitions against state intervention is kind of always a little moving target based on who's in charge, is try to do as much possible and cover as many borrowers with the protections as she can. If there's kind of a discrepancy, I think it's less on the state of Maine and more on Congress and the Office of the Comptroller of the Currency. So I think what this bill does is try to allow you all to protect as many people as possible. Federal law just carves out national banks from some of the protections here. I think what this would do to kind of remedy that is like further eliminate some of the protections for Maine state chartered institutions. That's just like a policy decision for you all to make, which is to get parity by carving out more borrowers and more protections, or realizing that states, can try to get to the line of who they can and can't cover. So that really is kind of just a policy decision for you all. What this would do is ensure, what the further amendment would do is ensure that, protections like total and permanent disability, while lenders in the state of Maine from Maine chartered institutions might offer that, it wouldn't be required. We wouldn't know what institutions going forward would do, but that's the impact of that would be for borrowers who took out loans from these Maine institutions, the protections underlying this bill would not be afforded to them.
Okay, thank you. Representative Tepler.
Thank you, Mr. Frotman. So do you feel that there are ways in which state chartered banks then could counter the competition, let's say, on this somewhat uneven playing field by pointing out the protections that are provided through Maine law from state chartered banks to encourage borrowers to work with state chartered banks?
I think that's a great question. I think in my experience, I've seen that affording these protections to borrowers really matter. Take, for example, the issue around cosigner release. This is the ability for a cosigner after a couple years to get off the loan. A lot of people who cosign a loan kind of know what they're getting into and they're quite petrified of it, but they also know it's the only way that their child or grandchild could, afford to go to college. So we see cosigner relief being offered as a marketing tool, right? We provide this for you as a consumer protection because we know you're kind of skittish about cosigning. And I think to your question, I think this can be a valuable addition, both in terms of providing a real service to borrowers, but then also, promising and then delivering on a benefit that can distinguish them from a Wells Fargo or another nationally chartered bank. So I think it's a great question and an opportunity for institutions to, not only market on price, but also market on service and customer responsiveness.
Representative Evans.
Thank you, Madam Chair. I think you may have answered my question, but if you could, I understand the concept of more protection for Maine borrowers under this scenario. I'm unclear still about the extent of involvement that could result with the Wells Fargo, and what protections would you Mainers have under those circumstances? How would that be handled? I'm not clear about that.
Yeah, so it's a great question. So kind of you guys have probably dealt with this before, but kind of overgirding all of kind of state consumer protection, especially when it comes to the financial sector, is the National Bank Act, and the extent to which national banks or federally chartered banks are exempt from certain state actions. There's some somewhat clear lines about the ability of, you know, your superintendent to go in and use their visitorial powers to kind of supervise a Wells Fargo and oversight. I think it becomes a lot more of a gray area in terms of whether or not some of these provisions fall within that bucket of what states can't intervene on. So, you know, I think there's questions about the ability of the origination provisions to apply or not. A lot of these questions, I think, unfortunately, states are constantly working in the unknown, because a lot of this depends about how the OCC is going to interpret the interrelationship between national banks and states. But I think what Senator Vitale has tried to do is craft a bill that allows the states to try to be as protective of its people as federal law will allow. And some of that, I think, is just, unfortunately, the calculus of the national bank regulators have gotten this wrong for a long time. And what this bill tries to do is just ensure that should this bill pass, the protections are expansive as possible, even as they relate to national banks.
Thank you.
Ms. Parent from the credit unions has her hand up, so I think I will bring her in as well. And we'll just get that whole conversation on the table. Good afternoon. Please go ahead and introduce yourself to the committee. And yeah.
My name is Ellen Parent, and I'm with the Maine Credit Union League. And I just wanted to be here to answer any questions that you may have. Also, Representative Evans, to more succinctly answer your question, no, Wells Fargo would not be regulated under this. If there's no exception for state charters, this would still cover federal charters. This still wouldn't cover federal charters. So they're already exempt. This is going to hit on the credit union side, your Maine State Credit Union, your University Credit Union, which was a pretty big player in the in this arena, and also on the bank side, places like Bangor Savings Bank. Those are the ones that are going to be regulated in this manner.
So, Ms. Parent, can you speak to whether the contents of the borrower protections that are in the substance of the bill are the concern, or whether it's just that the regulatory playing field? Like, I understand, I've been on this committee for 5 years. I know that the banks, state banks and state credit unions are always going to come in and oppose any bill that doesn't that applies to them and not to the federal charters. That's sort of baseline. But sometimes there's also, and this would hurt us because we can't follow these rules and still make a profit, or we can't follow these rules because we think they're bad rules. And so I'm trying to understand if this is just a playing field issue, or without substance, or whether this would actually make you change the ways that you treat student loan borrowers in Maine. And if so, is that a bad thing?
Sure. So there are a couple of different things I can say to that. One, yes, you're completely right. We certainly have an issue with an uneven playing field. But that uneven playing field, is the extent to which it would apply would change the way we, if we offer student loans. Frankly, with a private right of action, I would expect that you would see, if you certainly wouldn't see any state chartered credit unions entering the space of student loans. And I think it's very likely you would see them leave. I would predict that you're going to see them sell to large out-of-state servicers, which I don't think is what the proponents of this bill want. And I think that you would be eliminating choices on the behalf of the consumers. So,
Ms. Parent, can you speak to the issue of total disability discharge or cosigner discharge provisions that state chartered credit unions and state chartered banks in Maine are currently providing?
Sure. So I have looked into this. I can't speak for all of them, but I know that I believe that there are some, I can't speak to every credit union, but I know that there are some that will offer total disability forgiveness. We did get this amendment just this morning, so I haven't had a chance to reach out to everyone in our constituency who is offering these. I know it's a common thing to be included in student loan borrowing. As far as the co-signing, that I would also have to check up on.
Okay. I think those were provisions in the original bill, not just in the amendment, but.
Yeah. But I mean, we're looking for an exemption. So I know that I believe Kathy Ken-Boris is on it. She may have been able to reach out to her membership.
Okay. All right, I will bring Kathy in. We're just going to have a big crew here. Good afternoon, Ms. Ken-Boris.
Good afternoon.
So do you have some, I mean, it's easier for us to provide this exemption, I think, and to like swallow the exemption if we're pretty sure that Maine borrowers are already having the experience of easy cosigner releases and full disability discharges. But if that's not the case, then it's going to be a little tougher because we're going to not be protecting as many Mainers as we could protect. So can you speak to that?
I cannot speak to a number. I do know that state chartered banks right now, unfortunately, a lot of them do not offer student lending. Our concerns primarily with the bill are not the components of what the bill does, like releases or releasing cosigners or death. What we have a problem with is the fact that if you're a state chartered bank now, if you were to pass this law, not only would they be under the rules of the Bureau of Financial Institutions for unfair and deceptive acts and practices, which they can do now, and also cease and desist orders, but also the private right of action. We're concerned about compliance. That's the primary thing. We raised in our testimony about Maine's Truth in Lending Act, which has some private lending rules in it, but not extensive. But that, and we have to adhere to that. if at the federal level they were ever to change and add these enhancements, but even a minor little change in a definition or something automatically flows into the main law without any legislative input or any bureau regulatory input. So there could be a conflict in two laws within the state, and it would be impossible for our members to adhere to two laws that might have different definitions. So in that case, a private cause of action for any reason, if they were to not do something properly due to just an error, they could see themselves in court. So when they're looking at assessing entering a market, they look at the potential risk. And what we want to make sure is that they have a level playing field so that they can enter with a limited amount of risk. Right now, Wells Fargo was mentioned. You know, the private right of action may not apply to them. They also wouldn't be under a potential cease and desist order or unfair or deceptive acts and practices. So it's more the compliance with the law than the components of the law is what we are concerned with, if that makes sense.
It does, but I'm still trying to figure out how we get more Mainers protected from these issues around cosigners, around disability discharge, and around some of the other sort of types of expectations with student lending. And, you know, we're in a place where, you know, we're not getting any information about what the current practices are of the banks, but we're trying to get an exemption from a regulation. So that's what I'm struggling with. And I understand there aren't that many community banks in Maine or state chartered banks in Maine that are doing student loans. There are, or at least there's one credit union that does a lot of them. It would be really helpful to know, you know, what their standard practice is with regard to these issues. I suspect it's good. I used to serve on their board, but I have no idea what the answer to this is.
Yeah.
And I'm just feeling really uncomfortable. I can see Ms. Parent like smiling, but I'm feeling really uncomfortable without knowing whether these loans are, you know, subject to different terms than the ones we're going to require of these private lenders.
If I may.
Yeah, go ahead.
I mean, so one of the things to bear in mind is that I suspect you are correct. And we were working on reaching out to the CEO over at UCU. But one thing to consider is that you're already going to be exempting, of Maine's 54 credit unions, 12 are state chartered. So you're already going to be saying that any of the federal chartered credit unions in the state of Maine don't have to apply to this bill.
So Ms. Parent,
I realize that
we wouldn't be saying that, Congress would be saying that. And so I think that was Mr. Frotman's point, you know, and I understand it wasn't the most like direct answer, but it was true that, you know, we regulate health insurance a lot as well, and we can't regulate federal RISA plans, but it doesn't mean we shouldn't protect Mainers to the extent we can, because that's our job.
Right. But what I'm saying is that if you eliminate one avenue for Mainers, you're going to see them leave. You're going to see your institutions, your local institutions, leave this area, and unfortunately, those loans are not likely to go to another Maine institution. They're going to go out of state. They're going to go to Sallie Mae. They're going to go to Wells Fargo. They're going to go to those big organizations, and I don't think that's the kind of path you necessarily. I mean, maybe you do want to take that path, but it doesn't seem like it would be beneficial for Mainers. or
Yeah.
for financial institutions. in the
And
state.
I don't want to disagree with you on that, which is why I'm trying to understand the lending practices that are in place today if we don't pass this in a way that would include state chartered financial institutions. So it may be worth holding off and waiting to actually figure that out. I realize that UCU could change their lending practices at any time, but it would be helpful to know if our baseline is this isn't a problem. Because we often exempt banks and credit unions from these types of consumer credit laws because we are convinced that this isn't a problem in Maine banks. And I haven't been convinced of that yet with regard to the Maine banks and credit unions that are doing Maine chartered banks and credit unions that are doing student lending today. I suspect that if I had that information, I would be convinced, but I don't have it. So I'm concerned that I'm leaving people exposed that I could be protecting if I exempt you. And that's the piece of information I guess I'm trying to track down. Representative Tepler?
Thank you, Madam Chair. I guess I remain somewhat confused about how including these consumer protections in Maine chartered banks and credit unions student loans disadvantages these institutions in comparison to federally chartered institutions.
It leaves them exposed. I'm just going to answer. It leaves them exposed to lawsuits because there's a private right of action. And so any sort of misstep in the implementation of compliance with these regulations could leave them exposed to a lawsuit. I think that's the answer. Mr. Lorando has his hand up, so I'm going to bring him in as well. Good afternoon. Is there some information that you wanted to provide to the committee?
Yes, I just wanted to provide comment on your question, Senator Sanborn, about whether or not this is something that is a concern for Maine state chartered banks and credit unions. The Bureau has a dedicated consumer outreach specialist on staff who handles all sorts of consumer complaints, ranging from fees to loan issues. And in my experience with the Bureau, and I also discussed this with her earlier, we do not get many complaints regarding private student education loans. So whether or not that speaks to the efficacy of consumer protections, that's again a policy decision that this committee has to make. But in my practical experience, this is not something that we see often. Okay,
that's helpful feedback because I think at the federal level you do see it often. So that's helpful. Representative Tepler.
Thank you, Madam Chair. I guess I need to hear that from Mr. Lund as well, because he's our designated student loan ombudsman, which may be why the Bureau is not getting very many of the complaints anymore.
Maybe. Superintendent Lund, go ahead.
Sure, I'd be happy to respond. I think even if banks and credit unions, state charter banks and credit unions were exempted fully from the bill, you would still have 85 to 90 or even 95% of where you want it to be in terms of encompassing this area of regulation. Of the types of complaints that we've heard about, for example, moving the goalpost ahead or changing the terms of an exemption that was promised at a time somebody co-signed, if state chartered banks did engage in that practice, either Gordon's office would hear about it or mine would. And I can tell you that we have not heard that type of complaint against state chartered banks or state chartered credit unions. I would also just point out that the Student Loan Bill of Rights does currently exempt state chartered banks and credit unions from the definition of student loan servicer. So again, I understand the concept of wanting to protect as many folks as possible. But in my personal experience, we have not, in my personal experience, the kind of behavior that we've heard about being a problem has not surfaced or has not been, the source of those issues has not been state chartered banks and credit unions. If it were, we would have heard about it. And frankly, the Bureau of Financial Institutions has pretty good authority over state chartered banks and credit unions. And even if there was a defense, I think the banks and credit unions would likely comply with the requests or suggestions of the Bureau of Financial Institutions.
Okay. I am going to suggest that we take a 5-minute corner caucus on this. And so we will come back at about 2:25, we'll call it. So that's like an 8-minute corner caucus, but I think that's fair. And so we'll see you back here at 2:25. Okay, our folks are coming back. I'm actually going to send folks back through the wormhole who had joined us to participate. Whoops, I don't want to send Sabrina back. That would be wrong. There we go. Wow, there were a lot of people. Okay, pushing it all back. Okay, hopefully I didn't demote any actual committee members by accident. And I didn't, so that's good. Okay. Folks are just switching from one Zoom to the other, so I'll be here shortly. All right, I think Representative Tepler is on the phone, so I think we'll just get started. I'm going to move ought to pass as amended, but with the same language from the Student Loan Bill of Rights that exempts state chartered banks and credit unions. I would like to add a provision that says something like the remedies provided in this section are in addition to any other rights and remedies conferred by law, to make clear that that actions on a student loan might arise under some other part of law as well.
Would you otherwise keep the other changes? In Senator
So I think,
Vitelli's?
Colleen, I couldn't hear you. What did you say?
I was going to say, were you?
No, we can't hear you. You must have the wrong mic going because you're not on mute.
Let me double check. What did I do?
Oh, is it just that I don't have my computer? Never
that-
mind. My computer
Can you
was
hear
on
me?
mute.
Oh.
Sorry.
That's okay.
All
Can
right.
you hear me now?
Yes.
Okay.
That was just me with
Okay.
my computer on mute. I apologize. I've just been
No,
talking.
sorry.
Go ahead, Colleen.
I was just trying to clarify that you would otherwise keep the changes proposed in Senator Vitelli's amendment, but put the exemption in?
I think the other change in the amendment is related to fame.
Mm-hmm.
And then I think all the other amended language is related to trying to keep banks in, but I could be wrong.
Well, there were some other like technical changes, like making the rulemaking discretionary as opposed to mandatory, and some other changes as well. So I just wanted to confirm that part. So otherwise those changes are fine, but related to provide the exemption to conform with the existing provisions in the Student Bill of Rights for banks and credit unions. Okay.
Mm-hmm. Yeah, and then I would also want to add the cross-reference to Senator Bennett's bill.
Yep. Okay.
Is there a second?
Thank you.
Okay, Representative Bleier wanted to ask something, or are you second?
Yeah, I want a question.
Okay, go ahead.
Yeah, so this will exclude credit unions and local banks. Is that correct? The exemption? Yeah. I will second.
Okay, great. Are there any other questions or comments? All right, seeing none, I think we're ready for the vote.
Representative Quint. Absent. Representative Connor.
Yeah.
Absent. Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson. I think you muted yourself before you said it.
Yes.
Thank you. Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks. Absent. Senator Stewart. Absent. Senator Brenner.
Yes.
Representative Tepler.
Yes.
Senator Sanborn.
Yes.
9 yes, 4 absent.
Okay. The next bill is LD 1648 regarding lab tests and imaging in the state employee plan. And I'm not going to have Colleen do her analysis presentation of this. I'll just start by saying that I think that while the bill as written isn't like spot on to address the concerns that Senator Jackson's constituents have, there are real problems with this program. And so I want to propose that we vote on not to pass on this bill, but that we send a letter to the state employee health executive director. I think that's the right place to send it, Colleen. And I want to identify 3 issues in our letter with this particular benefit design. The first is a lack of geographic inclusivity. The second is a lack of sort of efficacy. It's almost like hit or miss whether people just happen to go to an independent lab or know about it because people don't really seem to be utilizing it as a cost savings incentive program that it was supposed to be. And the third problem is that bills are not being processed correctly so that enrollees aren't getting the benefits when they are following the rules in order to get them. So I want to identify those 3 problems and ask the state employee plan to get back to us with what they're going to do about it. They can just send us a letter back. It doesn't have to be like a report or something. All right. Does that sound good to everybody as a plan? Is there any further discussion? All right. So seeing none, I'll move ought not to pass with a letter. And it's seconded by Representative Tepler. Is there any further discussion? All right. Seeing none, you can call the roll, Sabrina.
Representative Quint. Absent. Representative Connor. Absent. Representative Blyer.
Yes.
Representative Morris.
Yes.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks. Absent. Senator Stewart. Absent. Senator Brenner.
Yes.
Representative Tepler.
Yes.
Senator Sanborn.
Yes.
9 yes, 4 absent.
Great, thank you. Okay, so the next bill is 1706, cost sharing for generics. And again, here in the interest of time, rather than going through the full analysis, I'm going to recommend that we carry this bill over. It needs substantial work before I could support it. In particular, the exclusivity period after a brand new drug comes out needs to be addressed. After a brand new generic, first to market generic comes out, needs to be addressed. There should be no preferential tiering during that time period. And just in general, figuring out how to make sure that this bill doesn't end up benefiting generics manufacturers rather than main consumers is what we need to do. Because I think as drafted, it's designed to benefit generics manufacturers, and I don't think they need our help. I think it's main consumers that need our help. So I'm going to recommend a carryover. Is there further discussion? Representative Morris.
I was just going to make a motion to carry over. I agree with what you said. I think I have similar concerns, but am willing to support a carryover on this. So.
Okay, Senator Brennan.
I'm seconding a carryover.
Okay. Is there any further discussion? All right. So we'll do we call the roll on this, Colleen? I forget. It's been a long week and it's Tuesday.
I think we have been. It's probably good
Okay.
to tape a record.
Perfect. Sabrina, you can go ahead.
Representative Quint, absent. Representative Connor, absent. Representative Bleier.
Yes.
Representative Morris.
Yes. Sorry. Take a minute to get the.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner.
Yes.
Representative Tepler.
Yes.
Senator Sanborn.
Yes.
9 yes, 4 absent.
All right. And so the last bill for today is 1725, the deferral of the pooled market. And Colleen, you can go ahead and do your analysis.
Okay, I will. So this bill is LD 1725. As Senator Sanborn said, it's an act of to clarify the deferral of the pooled market and link small employer clear choice to pooling in the Made for Maine Health Coverage Act. It does a couple of things. The first is it changes the effective date of individual and small group health plans that must be offered in the state through the pooled market from January 1 of 2022 to January 1 of 2023. It also clarifies that the implementation of the pooled market is preconditioned on the approval of a federal 1332 waiver that extends reinsurance to the pooled market based on projections both average individual and small group premium rates would be the same or lower than they would have been absent both the pooled market and the application of reinsurance. The bill requires the superintendent to develop clear choice designs for all individual plans with effective dates on or after January 1 of 2022 and moves the requirement for small group health plans to be contingent on when there is a pooled market. So clear choice design plans would move forward in the individual market only with effective dates on or after January 1 of 2022. And then small group would be added if and when the pooled market is implemented. The bill also clarifies that health insurance carriers may offer up to 3 health plan designs that modify one or more of the cost sharing parameters that are set forth in the clear choice design rules. And then finally, the bill modifies the permissible use of excess funds derived from assessments against insurers under the Reinsurance Association, and it delays the implementation of the requirement that Magera reinsure small group health plans in the state to calendar year 2023. So it delays that as well. There are, as I just included, links to the current law, both regarding the pooled market and clear choice designs, and Magera is found they're in 2 different chapters of the insurance code. You had heard previously from the Bureau of Insurance their intention to delay implementing the pooled market until plan year 2023. And so the bill makes the statutory changes necessary to delay that implementation, and also makes clear that the development of the clear choice design plans with regard to small group plans would not happen until the pooled market is implemented. You did hear some concerns which have been expressed in earlier discussions from carriers about the clarification to the standard for determining whether the pooled market moves forward. The baseline and current law for comparison purposes from the carrier's perspective should remain in place, but LD 1725 really reflects the Bureau's belief that the appropriate baseline is 2 separate markets without a subsidized reinsurance program, and that standard's the only realistic standard to apply, and that has been reflected in the approach that's been taken in the previous actuarial analyses. So one of the questions really is what standard should be reflected moving forward, whether it's what exists in the current law or what is proposed in LD 1725. We don't yet have any fiscal information. The last thing I would note is that you did receive some written testimony late this morning from Magera related to their written comments on LD 1725 as drafted. And I do believe you have representatives of Magera here if you're interested in hearing from them, as well as the Bureau of Insurance and representatives of carriers. And I'm happy to answer any questions as well.
Thank you, Colleen. Okay, are there questions for Colleen? All right. Seeing none, I have a sense that this might be a bill where we just have some irreconcilable differences. So I am going to move to pass. Is there a second? Seconded by Representative Evans. Is there any further discussion on the bill? Representative Morris, go ahead.
Thank you, Madam Chair. We would be, I think you're right. I think it is irreconcilable differences is probably the best way to put it. We would be fine with the bill, obviously, if Section 2 were removed, because I do think that was absolutely, it does not, I think it clarifies perhaps the administration's intent with the bill last year, but it certainly was not the intent, or the intent as we understood it from our side on the committee. We understood it to mean with the law as it currently is in place, a do no harm standard, not to use the standard of if Magara did not exist. So I cannot support the motion as is. I would support the bill minus Section 2, however.
Okay. Is there any additional discussion? All right. Seeing none, the clerk will call the roll.
Madam Chair, was there a second?
Oh, yes, it was Representative Evans that got the second. Thank you, Representative Bleier.
Okay. Representative Quint, absent. Representative Connor, absent. Representative Bleier.
No.
Representative Morris.
No.
Representative Matheson.
Yes.
Representative Evans.
Yes.
Representative Arford.
Yes.
Representative Malrano.
Yes.
Representative Brooks, absent. Senator Stewart, absent. Senator Brenner.
Yes.
Representative Tepler,
Yes.
Senator Sanborn.
Yes.
7 yes, 2 no, 4 absent.
And the minority report.
Ought to pass as amended, deleting section 2.
Great, thank you.
Okay. So that is the end of our work session list for today. Colleen, do you have any work for us?
I do not. I didn't have a chance to pull together the language reviews this morning, unfortunately, but I will have a few for you tomorrow. I've gotten a few more fiscal notes back for things that we can review, hopefully tomorrow afternoon. And then if you wanted to, we could have even more maybe on Thursday, depending on what your workload is. But I'm all set for today.
Okay.
Thank you.
Great. So we will be back tomorrow. Representative Bleier, go ahead.
Thank you, Madam Chair. Just a clarification, to be determined for Thursday. Are you determining what's going to happen on Thursday?
We don't have anything on the calendar for Thursday. We have scheduled everything, I think. And anything that's not scheduled, I think the intention of the committee is either that it would be withdrawn by the sponsor. There's a couple of empty bill jackets that we're planning to withdraw, or would be carried over without a hearing, which my understanding at this point is that we're not supposed to advertise those for a work session, but I'm advertising it right now that that we have one or two. Are there two bills? Two bills that we have not scheduled for public hearing, and the intention is to carry those over. One of them is about international reference pricing, and the other one is
Pet insurance.
pet insurance. Oh, right. The other one is pet insurance. So yeah, that's the plan. Okay. Anything else? Oh yeah, Representative Arford, go ahead.
I'm just curious about, we have a couple of letters, the letters attached to my bill 1531 to the Bureau of Insurance, the resolution, the joint resolution that we passed last week regarded to 1045. And when will we see those? How will that work?
It's language review.
But if it doesn't happen this week, what will?
It would come in an email to us, and then you would have 24 hours to respond to the email.
Okay, great, super, thank you.
Yeah, Representative Morris.
Thank you, Madam Chair. Just real quick on the housekeeping piece, I guess I'll ask Colleen, was there anything else I need to do with the bill I asked to leave to withdraw, or am I all set?
No, I forwarded, well, I sent an email today to Casey Milligan, and I've copied you and the other sponsor. I think Senator Sanborn's the sponsor of the other two. So she's all set. Once I got your email okaying that,
Okay.
she will follow up with each of you. I think you'll need to answer one of her signature required emails, but just look for that. But that's just a paperwork thing from now on. So that bill LD 752 has been requested to leave to withdraw, LD 122 and LD 1561 for folks who might be interested on those, what LD numbers those three are.
Okay, thank you.
Yep. So the rest of everything is scheduled for tomorrow's work sessions, and we'll take those carryover votes tomorrow on those two bills as well. And
we should finish.
Then that's everything, unless we end up tabling anything tomorrow. And then that's sort of why we saved Thursday aside in case anything got tabled today that we needed to come back to on Thursday.
Or in case there's any particular language reviews. I
Right.
do have a lot of things to draft. I do have a lot of letters to draft. I have a lot of amendments to draft. I'll do my best, but I don't know that I'll have them all ready for you Thursday.
Fair enough. Okay. Representative Tepler, go ahead.
Thanks. So Colleen, in the past, we've done language review by email. And is that the ongoing plan for the work that you still have left to do?
I think so. I mean, the committees have the opportunity to meet through Zoom through the end of this week, and I think even Tuesday. There's no session scheduled on Tuesday, so if the chairs wanted to schedule a quick meeting to do language review by Zoom, we could. Otherwise, after that, I think once session starts, it becomes harder to schedule. Obviously, with Zoom, it'll be harder to schedule. So we typically will revert to language review by email, which we've done in past sessions. Probably primarily for the fiscal notes. My hope is that I can get you all the language pieces, at least, you know, to take a look at before, if not by the end of this week, before Tuesday. So if you wanted to have an opportunity to talk about it, you could schedule a Zoom if necessary, and then follow up with any fiscal information later, if needed. If that works.
I think it probably does. Thank you.
All right. Anything else? All right. We will see everybody tomorrow. We start at 11 o'clock tomorrow instead of 10 o'clock. So we will see you at 11 tomorrow.
Thanks, everybody.
Thank you. Have a good evening.